Hello, everyone, and welcome to another episode of Sterling Live, our first episode of 2020. Thank you all for joining us. I know it's been only a couple of weeks since I last saw you all, but we are in a new year. We have a ton of great stuff coming out for Sterling Live in 2022. So I'm so happy to be kicking off this new year with this episode. This is a great topic, I think, to kick things off with. So let's, not waste any time and get right into it. Just so everyone is aware, my name is Caitlin Brower and I'm Sterling Social Media Manager. And Sterling Live is our weekly live series on LinkedIn, Facebook, and YouTube, where we sit down with all of our great leaders at Sterling, all of our experts, everyone that you want to see week after week, just giving you guys the best of the best content. So as you can see, I've got two great guests above right here. I know you have all seen Angela Preston before. She is a return guest. We also have Chris Christian here as well. He's a newbie to Sterling Live. So thank you both for joining. So Angela Preston is our Senior VP Counsel of Corporate Ethics and Compliance. And Chris Christian is the Director of Compliance for Sterling. And as you can see on the bottom, our topic today is background screening in 2022, key compliance trends to know. So I do want to hand it over to our guests to give them a moment to introduce themselves. So Angela, we'll start with you.
Great. Thank you for having me back, Caitlin. It's great to be here in the new year. This episode, I think, is just sort of a follow-up to a webinar that we did at the end of the year in December about what we see as the key compliance trends, legal issues that are hot and that we see continuing into 2022. There's never a shortage of legal and compliance related issues when it comes to background screening, and hopefully the content that we want to deliver today is really to highlight what we see as some of the key trends. And as far as, those of you who don't know me, my background, I'm head of compliance here at Sterling. I'm an attorney. I've been in the background screening world for 20 years now, just focusing my career on the legal and compliance related aspects of background screening, and that really expands and has expanded as screening has become an integral part of hiring and employee onboarding, and we have really expanded the scope of what we look at in terms of regulatory and legal compliance to issues around identity and all levels of consumer protection and EEO laws that relate to hiring and how protections for candidates extend to the screening process and how that works in with clients and different organizations hiring programs. So it's really anyone who's hiring in the world is doing some type of background screening, and we really focus in on the legal and compliance issues related to that. Our focus for today is really U.S. Trends, and we're excited to dig in and talk about it.
Definitely a lot to talk about. So thank you, Angela, for providing a little bit more in regard to the topic and your role at Sterling. Chris, welcome to the show. Can you go ahead and introduce yourself to our audience?
Sure. I'm Chris Christian. I'm Director of Compliance here at Sterling. I report to Angela. I've been with Sterling for 5 years next month, and I've been in the industry for 17 years. Mm-hmm. And this is my first live event with Sterling, so glad to be here. I know normally the spotlight's on Angela, so sharing the spotlight with her is very cool. So yeah, I'm pleased to be here. So this is great. I think on these topics where I come in and intersect is while we're talking about these things today at a high level, I think where I see myself in the weeds and making these things happen at the granular level within the business. So yeah, it's nice to kind of step back from the details a little bit and talk about it at a higher level.
Absolutely. And Sterling Live is cool. So I'm so happy that you said that. And it is great for the both of you to be here. And yeah, we have such great expertise with compliance at Sterling. So it's great to showcase both Angela and Chris and to really everyone watching to help you and provide guidance with what you need for your organization. So with that being said, we are going to cover a couple of different topics today, but if you are watching live right now on Facebook, LinkedIn, or YouTube, if you have any questions for Angela or Chris throughout the show, please go ahead and put them in the comment section across each of these platforms, and I'll get them over to both of them as I see fit throughout the show. So just a reminder, if you have any questions, please go ahead and get them in the comment section. So as Angela mentioned before, we're really going off of a webinar that we had on December 16th back in 2021, where we were prepping organizations, helping organizations to look at background screening in 2022 and looking at these compliance trends. So the webinar was great. I was there, there for the entire thing. A lot of great information for sure. So we started the webinar with a poll question though. So we asked our audience how they felt for this statement. I feel confident in my background screening compliance processes going into 2022. So 72% of our audience said yes, they do agree with that statement. So they do feel confident. But then 28% of that audience attending the webinar said no, that they don't feel confident. So to start off today's show, I just kind of want to get both of your thoughts on this data here. So again, real quickly, 72% of individuals were feeling confident about background screening compliance, and 28% were not. They responded no. So Angela, I'll start with you here. Just your general thoughts on this data.
I think it's great. I think that a high level of confidence is fantastic.
Mm-hmm.
It could mean a lot of things. I mean, it could mean that we're doing a great job of getting, communicating the issues out there and people are listening and feel good that they're well informed. It could be that our audience is particularly well informed. But, I think there's also, you don't know what you don't know. This is sort of a time of transition in the world. And there is, on a lot of levels, there is uncertainty around, some of the things that we are going to be talking about today, and a lot of transition at the legal level, at the courts, with legislation, and particularly at the state and local level.
Mm-hmm.
So I think that it's important to keep your ear to the ground, and if you're confident and you feel good about it, great. If you have great partners and legal counsel that's helping you keep informed and your team is on it, that's great. And I learn something new every day.
Right.
So I feel like only by sort of keeping the finger on the pulse of things and having function in your organization that's really dedicated or responsible with keeping up with things, it's easy to sort of get a false sense of security out there too, because things are changing all the time.
Mm-hmm.
And for us, it's a full-time job of just keeping up with the latest and greatest.
Absolutely. Chris, what are your thoughts on that data that we got from the webinar?
Yeah, I think when I see those numbers, I agree with Angela. That's a great rate of people who are comfortable with it. But being the compliance person that I am, I'm also concerned that, to Angela's point, you don't know what you don't know. And
right.
In our industry, what you know today may have changed, may change tomorrow. So if you're very confident, that's great. But that doesn't mean that you shouldn't continue to circle back and make sure what you think you know is still, the facts today as they stand. I think if you're in that category of folks who you're not comfortable or you're not confident, I would say write those out. Write out what specifics you're not comfortable with, as opposed to just an overwhelming sense of anxiety in general. Try to focus your attention on a couple of specific things and just eat an elephant one piece at a time if they're big problems. So.
It's funny. You're not the first person to bring up that the elephant analogy of on Sterling Live. We've had that come up before. So, and that was like the first time I heard it, like a couple months back. So I'm laughing now because I'm hearing it again. I love it. It's one of my new favorite analogies. So I think that's great. But like, as you both said, so it is a good ratio of people feeling confident. But I think the important thing that both of you had mentioned was, we don't know things that we don't know. And this is constantly changing, constantly evolving. There is something new that pops up every single day. So it is important for organizations to look to your partners, look to your providers, and really understand this landscape. So speaking of the landscape, from the webinar, we went through some of the popular topics that our attendees were engaged with. So today we want to go through 4 of them and just kind of elaborate a little bit more and just provide any guidance that we can. So real quickly, high level, we're going to be talking about FCRA Forms Compliance, state privacy laws, COVID-19 testing and vaccines, the decriminalization and legalization of marijuana, and then just, anything that comes up through the show we can address. So Chris, I'm going to start with you with FCRA Forms Compliance. I have a couple of questions here for you. So to start, can you provide an overview of what these requirements are?
Sure. So under the FCRA, just kind of focusing on the federal law, the requirements are there's not many. It's just that there's confusion about it. But the requirements really are that you should be providing a disclosure to your applicants, and you should be collecting an authorization to do a background check. All of that happening before the background check itself, and then what the FCRA basically says is that the disclosure needs to be clear and conspicuous, and that it needs to be standalone. And then additionally, you are going to want to layer in state disclosure requirements once you kind of bounce out of the FCRA and get those disclosures. If there's a state specific disclosure, California is an easy example to provide. And get those things in front of the consumers, and then collect the consent portion. And generally, they need to be separate. Your disclosures and your authorizations need to be separate. And your state and federal disclosures should probably be separated as well, so that everything is very simple and easy for your applicants to follow. And then at the end, once they've been presented their information, they should be afforded the opportunity to authorize it. And then additionally, there's also a federal summary of right notices that the employer should be providing to the applicant, and then along with any state specific notices. There are certain states out there that require certain specifically prescribed notices that need to be provided to the applicants as well. So in a nutshell, that's kind of what the FCRA says, and then, like I said, a layer of state laws as well.
Mm-hmm. So historically, this has been a topic of confusion and litigation for employers. Can you explain why that is?
Yeah, I have some theories, and I'm sure Angela has some thoughts on this as well. I think first of all, speaking with employers in the past, I think the language clear and conspicuous in the FCRA is probably an area of confusion, because that language or that terminology is not necessarily defined in the FCRA. And when that's left to courts to decide what that means and how it's interpreted, I think you get different opinions on what that means based on different courts, right? But even courts aside, if you put 5 people in a room and said, tell me what clear and conspicuous means, I think you'd probably get 5 different interpretations of it. If you had 5 lawyers in a room, you definitely get 5 different interpretations. That's a lawyer joke from my boss there. But yeah, I think that language is problematic in that it's confusing. While it's well intended, right? It's clear and conspicuous, and you think, right, that sounds great, but what does it actually mean in practice when you put it in a form or a document? I think it's left to be open to interpretation. And then when you have different courts around the country that have different views on it, it doesn't give employers a very crystal clear line of sight as to what a disclosure should or shouldn't have in it. And so I think that's probably one of the biggest areas of confusion, and therefore litigation, right? So if litigators know that that's an area of confusion and there's kind of a legal precedent for that, I think they will pounce on that and jump on it and test to see if your disclosure forms, your authorization forms are up to par. So
yeah, and I can layer in a little bit there. I think Chris is absolutely right. It's the language of the statute itself is there's very little guidance provided by Congress or by the regulators around that language, and the text of the statute itself gives a little bit of an option to include the authorization with the disclosure. So it says a clear and conspicuous disclosure consisting solely of the disclosure. Oh, but by the way, you can include the authorization with the disclosure. Well, at your own peril. I mean, basically what the case law has said is, okay, well, if you add these other things in, you lose on clear and conspicuous because you can't have it both ways. You can't put in a lot of additional language with state specific guidance or disclosures or instructions on how to get a copy of your report or other things that you might think are helpful for your candidate.
Mm-hmm.
Of course, you said these things make it less clear and less conspicuous, and therefore technically violate that part of the statute. And so it leaves employers in a pickle. Like,
yeah,
how do we interpret this? So, what we provide samples, different attorneys have, really drilled down into this, and you can talk to your law firm, talk to your outside counsel about what they recommend. Clean, straightforward, simple language, strip it down to, the FCRA disclosure, really to get to that clear and conspicuous standard. Otherwise, you could potentially be inviting a challenge. So,
right.
And we continue to see this. This is a trend because it continues to be litigated, even though we thought that we had put these issues to rest years ago. We continue to see this, and we continue to see different, even more, aggressive challenges on this front. So, again, it's never a bad idea to revisit your forms, put it into your calendar, schedule it with your outside counsel or your in-house counsel, whoever is managing the process. Talk to your screening company and put it on your list for 2022 because it continues to be a trend that you need to address.
Yeah, some good tips there, for our audience to take and, really look at and understand. But, Chris, do you have any other takeaways for our audience in regards to FCRA Forms Compliance?
Yeah, I'm just going to echo what Angela said, which I kind of covered when we had the presentation a couple of weeks ago, which is you really need to put it on your calendar. Like it's just that important to be on your calendar once, twice, maybe even more. To revisit it. It may just simply be that, you spend an hour on it, but that's fine. I mean, to think it's a one and done kind of concept, given what the litigation landscape is right now, I think that would be a big mistake. And I would caution anybody out there who thinks, hey, we've written it, it's fine, we had legal counsel look at it, we're good, or we outsource that to our background screening vendor. Like, you really need to make it a top shelf priority for your business if you're doing background checks.
Well, I hope everyone watching either has a Word document open or brought their pen and paper, because already we have some great takeaways here. So I hope everyone is paying attention and, taking the advice from both Chris and Angela. So let's move into state privacy laws. So Chris, we'll stay with you. Obviously, Angela, chime in as you see fit for these questions. So privacy laws are considered, a patchwork of laws. So can you explain to our audience what that means?
Yeah, sure. So, in the basic, simplest terms, in this country, in the U.S., different types of information are regulated by different laws, which are enforced by different regulatory agencies, and we're talking about at the federal level. And now we're starting to see states apply a layer as well: California, Colorado, and Virginia. So by way of an example, I'd say, like, for example, health information is regulated by what's known as HIPAA, which that's a regulation governed by the Department of Health and Human Services. Financial information is governed by the GLBA, which is the Gramm-Leach-Bliley Act, and the FCRA actually is a financial privacy law. I don't think many people think of it that way, but it is. And those regulations are regulated by the Federal Trade Commission and the Consumer Financial Protection Bureau. And then there's telecommunication and marketing information, and that's regulated by the TCPA, and that's, again, enforced by the FCC. So you get an idea that depending on what kind of information, it's governed in different ways. And so that's when we say it's a patchwork, a quilt, if you will. That's currently kind of how privacy in the U.S. is governed. Just depends on what type of information and who oversees that information from a regulatory enforcement standpoint.
Right. So for particular trends that we're seeing here, can you break down what these trends are, and then, like, with legislative and common elements, excuse me?
Yeah. So I think I'll start with legislatively. So in 2021, we saw 30 plus states propose regulations or bills to regulate privacy at their level. So I think for 2022, what we're probably going to see is an increase in that. And we're going to see states, and this has already kind of been a trend, we're going to see states probably reintroduce their same legislation that they've tried to pass for multiple years. Several states have tried to pass their privacy bills over the course of 2 or 3 years. So we're likely going to see states reintroduce their same bills. We're going to see some states probably introduce new bills that they've never produced before, because this is really a hot topic at the state level. And again, kind of what I talked about before, what's driving that is this patchwork of federal laws out there, but states are looking to now kind of get into the fray because not to get into federal too much here, but the experts in this area are kind of pontificating that we're not going to see a federal bill, especially in a midterm election cycle, because there's gridlock and not very much done, right? So that's kind of provoking the states to take more of a proactive approach to regulate privacy at the state level. And then I think from a legislative standpoint, we're also going to probably see some outlier states introduce bills that are different from the pack, right? A lot of these bills kind of model each other and copy each other. But every once in a while you have a state that says, hold my beer, I'm going to do it differently. California being one of those. New York likes to do that. So we know New York has a bill that's out now. So yeah, it's kind of that wait and see what these states are going to do legislatively. There's also a lot of debate, and I think there will continue to be a lot of debate in these bills. And I think this is the reason why some of these haven't been passed is that there's a lot of debate at the state level as to it's one thing to write a bill, get it passed, but there's an element to it of how are they going to be enforced, right? Are they going to include a private right of action for individuals, or is there going to be some kind of privacy czar or new regulatory body in that state? And if that's the case, you've got to create that, right? And so, if you have a state that's a red and blue state and it's real tight, you're going to have one side saying less regulation, point to the federal laws, and then the other side's going to say, no, we need to have more, and this is an area of concern for citizens of that state. So I think that's what we're probably going to see in 2022 from a legislative standpoint. As far as trends around the common elements of these bills that we've seen. I think a lot of what we've seen already in 2021 we'll see in 2022, which is more rights for consumers, right to access to their information, more protections around sensitive personal information, and meaning there will be definitions within the bills that define what is personal information versus sensitive personal information. And I think we're also going to see probably more rights on the collection and retention. There's some, I think it's important to note there's going to be some kind of probably privacy security measures, infosec, if you will, addressing data breaches and those kinds of things. So I think that's going to be kind of a trend that we're going to see in 2022. We're going to see more of that as far as like common elements in these bills. I think another piece to this is that we're seeing, and again, this is just from 2021 and what we think are going to be in 2022 is there's also going to probably be more focus on businesses putting in place, privacy, governance and policy activities within their business, right? And then requiring, distinct roles within a business to be a privacy officer or to be a privacy, director or something to that effect. And I think that's kind of going to be the new trend going forward. You've got to have privacy people, you've got to have compliance people, you've got to have legal people, and these laws are going to, they seem to be addressing and pushing businesses to do more than just writing a policy, if you will.
Of course. I mean, every company deserves to have two people like you both. So I think that's a good takeaway for sure. So we've covered two topics. We have two more to go. So Angela, we're going to talk about now COVID-19 testing and vaccines. So I do have a couple of questions for you here. So what is the current state of the executive order in place for employers right now?
So this has been a bit of a roller coaster, but the Biden administration back in September published, announced the action plan to require employers, large private employers, to have a vaccine program in place, and OSHA, the Occupational Safety and Health Administration, developed an emergency temporary standard that put in place the rules around private employers with 100 employees or more, the requirements around having vaccines mandated for the workplace. And the ETS, the Emergency Temporary Standard, was challenged in the courts, and there was a stay put in place. And now we've kind of come full circle. The Sixth Circuit did overrule the stay. And as of Monday, the vaccine mandate for businesses with 100 or more employees went into effect. Mm-hmm. And so it is now currently the law of the land, with one caveat that it did get challenged and filed with the Supreme Court. The U.S. Supreme Court heard oral arguments on Friday, and that is still, we still remain to see what the Supreme Court rules on this. But until then, the OSHA order is in effect as of Monday. OSHA has come out to clarify that they will not issue any penalties for non-compliance until February 9th. And really, that is the deadline for businesses to implement the COVID testing. Mm-hmm. So what the ETS provided was that those employers with 100 or more employees are required to maintain a database or a record of their workers' vaccination status, to post a vaccination policy, to provide paid leave to workers to go get the vaccine, And in the event that there are employees who have to visit the workplace but are entitled to a reasonable accommodation under the law, then those unvaccinated employees are required to wear a mask at work. Those are the pieces of this that really went into effect on Monday. And then those who are not able to get vaccinated or refuse to get vaccinated or entitled to accommodation to not be vaccinated under the law, then those employers have to have a testing program. And the program, or the deadline for that testing program to be in effect is what has been extended to February 9th. So it's a lot to digest for employers, and it is further complicated by the fact that there are additional mandates for different types of workers. If you have, if you're in the healthcare space, different types of health service workers, federal employees, federal contract workers are subject to different mandates. And then on a state-by-state basis, a number of states have put into place their own rules and requirements around vaccines and testing, and what needs to be reimbursed for paid time off or leave for getting vaccinated, or reimbursements for testing and so forth. So there's a whole really patchwork of laws that now are out there that employers really need to get their arms around in terms of an enterprise program, or if you're doing business in multiple locations or in specific types of services, that you really need to understand and sort of get your arms around as to how all of this applies to you. But it is real and it is live, and it is time for employers to kind of get their programs in place, looking towards the fact that OSHA will start enforcement very soon, as soon as February.
Yeah, well, good timing, I guess, for today's show then, because it is hot off the press. We are hearing more and more detail. But as you said, it is a lot to digest. There is a lot of information to look at, to understand for employers. So are there any other considerations that you would like to share with our audience that, employers really need to be looking at right now?
Yeah, I think that with remote work, I think that a lot of employers are still struggling with, we're in the midst of Omicron and new variant and a lot of disruption and uncertainty, not just in the workplace, but in our world in general. So I think that we're continuing to look at hybrid work options and remote work as a viable option. Keep in mind that if your employees are working remotely, these rules don't apply. So this is only applicable if you have people going to the workplace. Now, many of you have, essential workers who are either interacting with the public or required to be out in the world or reporting to a workplace. So but if there is an option, that option is certainly continues to be appealing for those that can do work remotely, because it does, eliminate the need for those workers to have to be subject to these types of rules. I think that that's going to continue to be a factor going forward in 2022. Testing is going to continue to be a part of our daily lives. Some of this guidance, some of the commentary has said that this ETS is already obsolete because of Omicron and because of what we're learning about the virus and the way that this is impacting our world. So this is something that you need to stay on top of just daily, if not, weekly, if not daily, because it is such an emerging area of compliance, and it really is changing from day to day.
All right, so let's move into something that it also is changing, and we are hearing a lot of new information on. Let's talk about the decriminalization and legalization of marijuana. So, Angela, can you just explain to our audience what the difference is between legalization and decriminalization?
Sure. So these are terms that are thrown around and often used interchangeably, and there is a technical difference. So when you talk about legalization of marijuana, what you're really talking about is a state or a local entity saying that it is legal to use that substance either recreationally or for medical purposes. That is not to be confused with decriminalization, where the decriminalization is saying that what was formerly a criminal act is now just a civil penalty, or something that's punishable not as a crime, but it is typically punishable by a civil fine or a civil citation. So it's the difference between saying this is legal to use in this jurisdiction versus it's no longer criminal, but it's still subject to a civil fine or penalty. And it's a subtle difference, but I think that it is important when you look at your screening programs and your testing, and whether or not you are you're making decisions about applicants or employees based on whether things are crimes versus whether things are infractions or civil types of offenses. So I think that thinking about it in terms of what's going on at the state or local level, it's something that you definitely want to kind of keep your pulse on, in terms of, if this is something that's a concern for your workplace and where, you have a need to test, and it is a priority for your organization, to keep in mind the changes in the laws and to adapt your program to make sure that you're talking about cannabis or marijuana use in the proper context, that you're not just talking about criminal activity, you're talking about even like how do you want to treat a civil penalty or a civil infraction. The other thing to keep in mind is, in some jurisdictions, it has become prohibited for employers to test or screen for marijuana as a condition of employment. So that is definitely something that employers need to be aware of. And the state of New York, Philadelphia, Nevada, all jurisdictions where there are newer laws, and we continue to see this as a pattern and a trend going forward, where not only is marijuana decriminalized, but it has become prohibited for employers to test as a condition of employment. So that is definitely a trend that you want to stay on top of and watch out for.
Yeah, I mean, definitely a prime example of what we are seeing certain states do. And like Angela had mentioned, we're talking about the difference, between decriminalization and legalization, but how that directly impacts an employer's screening program, and how important that is. So, be on the lookout again for certain trends, like what states are doing, and just being aware of everything that's going on. But are there any other particular trends or considerations that employers should be aware of, just in drug and health screening in general?
Yeah, I mean, I would say it's again, put it on your list to go back and look at your program, and what are you testing for and why, and is there a nexus to the job requirements? And obviously, marijuana is still a federally controlled substance. There's no question that employers have a right to consider that as an option if there is a nexus to the job and there are concerns if there are federal or contract requirements. There's definitely a need to do the proper testing and screening for drug and alcohol and substance abuse. But these newer laws, you need to go back and look at your program and where you're doing your screening and where your applicants are coming from or where they're residing, if it's remote workers, to see if there are laws that impact your screening program. So it's put it on your list for 2022. Look at your screening program, evaluate your panels. What are you doing? Are there, the other thing I would mention is, because of remote work, using kits, using remote testing, using different types of methods of collection are becoming more and more popular and more accepted in the marketplace. There are more options available. So talk to your screener. There's been a lot of disruption with supply chain in that drug collection process. Just being able to send employees to a place to go have specimens collected for testing, it's become more and more of a challenge with COVID and workers not being available to staff those different collection sites. So the whole thing has had sort of this domino effect, and remote kits and different methods like that have definitely become more popular. So keep that in mind and consider those options for your program.
Absolutely. So at this time, I do want to remind our audience, if you're on Facebook, LinkedIn, or YouTube watching us live right now, if you have any last minute final questions for Angela or Chris, please go ahead and put them in the comment box across these platforms. While we wait for any final questions to come through, I do want to get final thoughts from the both of you in regards to these trends, today's episode, anything like that. So Chris, I'll hand it over to you for final thoughts.
Yeah, I think 2022 is going to be a very busy year. I think we're going to see a lot of the same that we saw in 2021, and then we're going to see probably some new twists and turns on all the topics that we covered. But I think the top topics that we talked about today are going to probably just be leading trend examples. And again, I can't emphasize enough, you should be constantly reviewing your programs and contrasting that with these trends. I think these trends should probably be, your top bullet points when you're comparing your program to the topics. So yeah.
Angela, final thoughts for today?
I just think that, again, a lot of the trends are happening at the state and local level. So even with COVID and COVID testing and vaccines, there's so much activity at the state and local level. It's really hard to track all of that if you are an organization that does business nationally or globally. There's a lot to keep track of. So find good partners, work with your legal counsel, have your lawyer on speed dial. It's all manageable, but a lot of it is just the discipline of keeping up with the latest and greatest, and not letting these things kind of slip. You don't want to be the target of an enforcement action or a litigation, or even just confusion within your organization where clear policies make things better for employees and for onboarding and for your candidates. So keep up, and it's all manageable. The resources are out there. You just need to tap into it.
So a ton of great advice given on today's episode. We are so happy that all of you were able to tune in live with us. And then if you're catching this on demand too, that's great. But as Angela said, there are a ton of resources out there. So I'm going to give all of you 3 right now. So we did do the webinar, the background screening in 2022, key compliance trends to know. We did that on December 16th. It is now available on demand. So if you thought today's episode was great, you got to check out that webinar. It goes into this and more. There's topics we didn't discuss today. So a little bit of a teaser there. They go into it in a lot more detail. So definitely check that out. At any time, you can visit the compliance section on our website. So we have an entire compliance section on www.sterlingcheck.com with all resources, new state law, everything like that, Sterling Live episodes like this. So all the resources are there. And then today we are releasing, so if you're watching it on demand, its priority is live, but it is January 11th. We're releasing a new blog from Sterling's Mark Sword. It is called Trends in U.S. Privacy Laws, What Will 2022 Bring? So all of these will be linked on Facebook, LinkedIn, and YouTube. So we'll direct you all to this, all to these resources because we have a ton of them. But I just want to take this time to thank everyone for joining us. I want to thank our guests, Angela and Chris, who did an outstanding job. Always a pleasure to, have the compliance team on Sterling Live. You always provide just great advice, great tips for our audience. So I wanted to take the time to thank the both of you for joining me today. So that is our episode. As I said earlier, this is our first episode of 2022, and we have a ton of great episodes coming. I'm so excited for what we're going to be delivering you for the rest of the year. But with that being said, that is our episode. Again, Angela and Chris, thank you so much for joining me today.
Thanks, Caitlin. Thanks, everybody.
Thank you.